So good morning. You are with the House Government Operations, House Judiciary, and Senate Judiciary Committee this morning. We are gathering here together to have some time with Dr. Eitan Nasreddin-Longo, who is the co-chair of the chair of the Racial Disparities Advisory Panel, and Dr. Nasreddin-Longo is going to review with us some of the takeaways of the report that was published, I believe, in December. Is that correct?
That is.
So committees, if you are able to, you can go to the legislative website and find a copy of the report there. And so I would love to turn this over to you and have you share any prepared remarks, and then I will keep an eye on the participants list to see if folks have questions for you.
Okay. I will. My remarks are relatively short. I had a much longer presentation, but I figured for some reason, unaccountably, I should condense everything and make this as quick as I can and leave enough time for questions or comments that people may have. As you all know, Act 54, which created the panel in 2017, got the ball rolling. The panel had a rather rocky start. There was some friction between the first chairs and other members of the panel. It was awkward, and we don't really need to go into it, but it became clear at a certain point that I was appointed to the chair by the Attorney General, or to the panel. The panel voted me as the chair, and it has been that way since. We are required, as you probably know, to produce a report every 2 years that makes recommendations more or less to the amelioration of racial disparities in both the criminal and juvenile justice systems. This took rather a while. There was a fair amount of criticism that we weren't moving fast enough. I kind of came on with the belief that from my 6th grade civics class, that democracy is one of those things that's horrifically inefficient and really wonderful and takes some great deal of time. And I said, so we're going to take a great deal of time. And there was some criticism, as I say, of that. But what I was pleased by was the fact that we managed to produce a report that everybody on the panel voted in on. And I felt that that was really important, that we got as much buy-in as possible. I didn't expect unanimity. I was very pleased by it. And I think that part of that had to do with the fact that, as David Scher, who is on the panel, he is the Attorney General's representative, said, we were making remarks from 30,000 feet, which is to say very broad, very big. We didn't feel that we wanted to get too specific, because we also felt that that was the job of the legislature, the elected people. We would certainly make recommendations as to areas that we felt needed to be considered. And that is what we've done. We are now, just so you know, in the process of refining that, of getting down to perhaps 10,000 feet, and thinking about the fact that there probably will not be unanimity at that close range. And what does a report look like when we, in fact, do that? The big takeaways, one of the big things that Act 54 asks is that the panel address a public complaint process, how to institute, as it says, a public complaint process to address perceived implicit bias across all systems of state government. Again, spoke about this at great length, and the simple answer, the Reader's Digest redacted version that is reduces all the nuance, I should say, was that we didn't feel we should create a new body, that there was no real need for that, but that rather the Human Rights Commission could be beefed up. And we felt that that was an appropriate place to house a public complaint process to, in fact, address implicit bias across all systems of state government. We suggested that additional resources were needed to prioritize race-related bias complaints and to resolve them in a timely manner. The Human Rights Commission would have to establish the infrastructure that was needed to handle and redirect or resolve these cases, and also, of course, maintain data related to complaints and to outcomes. And we recommended, of course, that funding would be needed to support the Human Rights Commission's educational outreach and certainly training, caseload coordination, mediation, etc. One of our other mandates had to do rather dramatically with race data collection. The question was whether to expand law enforcement race data collection practices to include data on non-traffic stops by law enforcement. And I certainly can note at this point that Act 148, recently passed, has provided a path for implementation of data collection reform. And I can certainly let you know that we have been in a lot of meetings over the last probably 3 weeks with various actors in IT around the state and pulling that together in such a way that we can produce a report about data that is asked for by Act 148. And we will be doing that in association with the Sentencing Commission. Our report back in December spoke about the need to increase data collection that captures what we call the high impact, high discretion points that occur during judicial processes within the state's attorney's offices, the Office of the Attorney General, Office of the Defender General, and certainly, of course, the Judiciary. Then other high impact, high discretion moments, administrative processes within the Department of Children and Families, and certainly within the Department of Corrections. Other moments would include charging, bail and pretrial release, plea bargaining, sentencing, and the usage of alternative justice options such as diversion. We also feel that data collection needs to be improved with respect to law enforcement by providing resources and expanding them to include information about all use of force incidents. And of course, that's starting to be looked at now with S219. And we urged very strongly a commitment to staffing and other resources to collect and compile data properly using best practices, given that those change. There were other issues here that I can go through. Those were perhaps the large ones that the mandate from Act 54 required. Oh no, one other, racial profiling, in fact. We were asked whether and how to prohibit racial profiling, including implementing any associated penalties. This was somewhat more contentious because there are members of the panel who just don't feel very positively about the idea of creating new laws. And so we didn't get perhaps as far with this as we might have, but we did do some work. One of our recommendations was to ensure that Vermont statutes track federal requirements with respect to due process for those with limited English proficiency. And that would certainly include juvenile delinquency proceedings. Supporting the use of objective and simple screening tools by first responders to assess the need for mental health or substance abuse treatment and the involvement in this of behavioral health experts. Supporting the development and implementation of training to educate the public on their individual rights. The training should be focused on the people most affected by racial disparities and include training on where to report racially disparaging experiences. Next, implementing and expanding training for officers promoted into supervisory and managerial positions to ensure that people occupying those roles will hold all officers accountable on issues of race, racial disparities, cultural competency, and of course, data collection. We certainly were behind continuing to enforce high standards of training for all law enforcement officers to ensure cultural competency and adequate education in relation to matters of bias. And then lastly in this section, expanding and supporting the use of community policing approaches to law enforcement. Again, those were the big areas that Act 54 asks for the panel to consider. We did go a bit further, and we did so because people were thinking. I have to say, it's been a wonderful experience to work with this group of people. It is a platitude to speak of them as people of good conscience, and I now know why that's a platitude, because there's a lot of truth in it. And these people thought very broadly. There were a lot of difficult conversations. There were a lot of truly difficult conversations that I think brought forth some very interesting points. We spoke about training and outreach, needing more training in the area of racial biases, racial equity, cultural sensitivity, and understanding how these matters impact discretionary decision-making points, how they entrench, or how that kind of bias entrenches white supremacy in the criminal and juvenile justice systems. Training that exists for actors in these systems should be expanded to include members and staff of the legislature and citizens as needed. We also spoke about legislative inclusion. You may have heard the phrase, "not about us, without us." This is something that has come out of many minority communities. The point of this saying concerns the ways in which legislation that affects minority communities is usually created, and we felt wrongly, without the input of those communities. We were hoping that the legislative proposals that conceivably could impact minority communities could be vetted in some fashion that includes these often silent or ignored voices. We spoke again about home detention, the need for that, for individuals detained pre-trial, having the potential to help keep already tattered minority communities and families together. In this case, while the criminal process is underway. We focused again on mental health and substance abuse disorders. Of course, that's very much in the news right now in the wake of the killing of George Floyd. We believed that there needed to be expanded support of response teams that include experts in mental health and substance abuse disorders to assist in responding to behavioral health situations. The hope is that that would avoid unnecessary entry into the court system of people who really don't need to be there. And certainly reducing court involvement can reduce the impact of racially disparate outcomes. Staffing. The panel supported a move towards a more individualized approach to cases, one that is more outcome-based and designed to address the specific needs of each person in the criminal justice system. This requires a reduction in current caseload pressures. We spoke again, and this point sort of goes back to legislative inclusion in a way, impact upon people of color. We are concerned with conceiving of strategies to track and document the racial impacts of policies being made in the state. The creation of such legislation should involve the input of communities of color and that of bodies like the RDAP itself. we focused a bit on the matter of discretion, in fact, knowing that discretion is a cornerstone of the criminal justice system. We didn't feel it was necessary to speak of its known benefits, but in light of racial disparity in the application of the law, it was necessary, we felt, to speak of the many ways in which implicit bias can make its unacknowledged way into decisions made by prosecutors, law enforcement officers, and judges. It was felt that by several members of the panel that a system of oversight, of checks and balances, which does not presently exist for the aforementioned officials should, and that lack of oversight that currently exists contributes to the persistence of a problem for citizens who belong to communities of color. And that really is that's kind of the big takeaway in here. And we, as I say, are working currently on the data issue, which came up very happily in Act 148. That report is due to the legislature on the 1st of December. We're making great headway on it. Our next meeting is a week from tonight. And I think that probably covers it. At least it's enough. Can I answer any questions for anyone?
Thank you so much for that overview. And I see Senator Sears would like to ask a question.
Yes. Again, I'll also thank you for the overview and thank you for the report. It's very thorough.
My pleasure.
One of the places that I'm looking at is the bottom of page 8, staffing. And
I'm opening it up at the moment, Senator. It's one of those wonderful moments of having one computer.
I guess my question is, this is something that frankly, I think both judiciary committees and others in the legislature have strived for as much as possible, making the criminal justice system more individualized and the juvenile justice system as well, so that we're dealing with people's actual problems, because oftentimes, as you know, the crime may not indicate the level of dysfunction or the level of the problem. And I wanted to highlight that as an area where we could use ideas, help on how to make this better, because our goal has been, I think Representative Grad would agree with me, our goal has been an individualized criminal justice system that looks at the person and what their needs are and whether they need to be incarcerated, how long should they be incarcerated, if they should all be, and what are the alternatives to incarceration. I realize this report is about the impact on people of color, but I think in general, this has been our goal. I would like you to comment a little bit more about that particular section.
You would like me to comment more, sir?
Well, I'd like to know a little bit more about what went into the thinking of the panel.
It is sort of interesting because in a weird way, it imbricated very much with questions around mental health, because and I don't think I'm leaping too far logically here to speak of how mental health issues are so individual, so singular, and yet also the sorts of things that get people entree into the criminal justice system. I think we started there, and then we kind of went, it really is a broader issue of looking at each case more specifically, because in many cases, we certainly have this huge overpopulation of people of color. That may have to do with a lot of things, a lot of social problems that need to be looked at so that people are directed in different directions that might then, we would hope, reduce their involvement with the criminal justice system. And that was where that recommendation came from.
I appreciate that. I feel, I think it's more than just embedding social workers in police departments.
I think that's probably quite true.
Having adequate information about the individual and their needs before we make a sentencing recommendation.
Exactly.
And I appreciate that. I think it's important. Important. I'm not sure how we reduce current caseload pressures given the budgetary pressures, but it's something we should strive for. And frankly, one of the problems in the criminal justice system, it's asked to take on people with significant mental health issues that should be dealt with in a different system.
Right, right. And we were acutely aware of funding issues, of budgetary concerns. And there was a dialectic really involving most of our discussions that had to do with how far do we go? Do we really shoot for the moon? Do we back it off? And we really, in the end, decided to shoot for the moon. And part of that had to do with the fact that 400 years of racism took a tremendous amount of capital to put into place. What systemic injustice looks like in 2020 took a lot of money. And I'm talking about slave ships. I'm talking about the kinds of hearings that went on on the federal level to ensure the existence of gerrymandering, of redlining. I mean, there was a lot of resource allocation to create systemic problems. And I think once one gets to that observation, shooting the moon when you come to make recommendations like this seems like a reasonable thing to do, even if money may not at that moment be there. But the fact is, if it took that much to get here, it's probably going to take a fair amount to get away from it. And I would go so far as to say that if one doesn't think that, it's probably a bit naive. That doesn't get us away from the budget, but I'm just saying, I think that was certainly behind a lot of our thinking when we went for the moon with our report.
Well, I will say that, and you were involved with it, that the effort at Justice Reinvestment 2, by spending money that we're sending out of state currently,
Exactly.
and spending that on back in the community to try to provide alternatives for people is a step in the right direction.
Precisely, precisely.
Thank you.
Representative Colston has a question.
Thank you. And I want to thank you, Dr. Nesreddin-Longo, for a well-written and impactful report. And, you know, I believe that white supremacy culture is the air that we all breathe. Regardless of the color of our skin, we are all impacted by this system. So my question is, was there any conversation by the panel on what does dismantling this culture look like? What does mitigating this culture look like? Because for my brothers and sisters who identify as white, you know, you don't know what you don't know. And so any specificity about what that could look like?
Beyond the recommendations, the simple answer is no. We got very concrete. That was partly, I guess I have to take the blame for that. I was very much into, can we make concrete recommendations that actually can be worked on by the legislature, that funding could be dedicated to? That is certainly an area that the report is lacking in. I would defer to the people who are working on the curriculum, in fact, the people who are working on the what is the term? It's not culturally sensitive, it's culturally competent curriculum, and implementing that in the schools, that educational approach is certainly, and I'm a teacher, so of course I have a bias that way, but I think that is absolutely where this has to begin. And they are doing that. They are doing that. So I have to say, no, beyond the recommendations, we have not gone into the areas in the ways in which you are asking.
Thank you.
You're welcome.
So I appreciate you framing this and really helping to challenge us to see this as a broader issue, and also recognizing that that some of the investments that we need to make in order to correct this generations of disparity and bias are going to be significant, and that will take us time to to appropriate those resources in the right way. I think in that context, we recognize here in at least in House Government Operations and House Judiciary, we've talked quite a bit about this, that we have a few bills that are in front of us right now that are the ones that we can accomplish right now, but we realize that they are but small steps in this more systemic process, a holistic process of really helping all of our neighbors educate themselves and realize how they have been impacted by systemic racism. So we recognize that this is, we're at just step one, or not step one. I mean, we've done a number of different things, including setting up the panel that you headed up to bring this report to us. But there is definitely more that we can and need to do.
Sure. And, and there's a lot of culture change on a lot of levels that needs to happen. I mean, I was speaking with Assistant Attorney General David Scher the other day about the Cannabis Bill. And that had come to my attention, and sadly too late, because we don't meet as a panel until next week. But I kind of had a moment, thinking that if you just think of American history, the regulation of substances has, I think it's not too much to say, really contributed to the mass incarceration problem that we see nationally. So I kind of looked at that bill and had a moment of panic going, why is this not in front of the RDAP? And kind of, what do I do? And that's a culture change thing, that we need to figure out a better way to kind of get those bills to maybe the RDAP, maybe some other body in some way, that it's, that there is some assessment of racial impact. Certainly on a bill like that. I mean, that's, I must admit to a certain amount of trepidation that is as far along in committee as it is. And, I'm kind of like, oh God, I wish we could have looked at that. And of course, with COVID, I mean, everything is crazy. It's 2020, nobody knows what's going on. But, those sorts of things, culture change, that naturally someone would say, we need to get this through too, and get response from them. And then we need to have a way of, looking at it, coming back with concrete suggestions, comments, and so on. Those kinds of things. And that will take time to figure out.
Well, I can speak for myself, and hypothetically, if I'm chair of government operations in the coming biennium, I would welcome your feedback. Obviously, passage of the bill is a very small part of the implementation of a tax and regulate system. So there are other opportunities for us to hear your concerns. And in the context of tax and regulate for cannabis, we are, of course, in Maxine's committee talking about expungement of prior convictions. And so would welcome Maxine to jump in for a moment and just fill us all in on where the expungement process bill is right now.
Great, thank you. So we are currently working on it as passed the Senate in a larger expungement bill, but we are just focusing on cannabis, and I hope to pass that in our committee this week. Would be great.
Okay.
Yeah.
Thank you.
Yeah, thank you, and I thank the Senate for their work on it.
Representative Christie has his hand up.
Thank you all. It's great to see us all here today working on this together, both bodies, more importantly. This is a great opportunity for collaboration. And thank you, Etan, for being here today. I think your point's well taken about intentionality with regard to all legislation that passes through both bodies. I think that we have an opportunity, let's look at this in the positive, we have an opportunity to change the paradigm as far as how we usually review things. So why not take this opportunity and look at how do we evaluate the effects of our work as a body on both the racial and social equity directives across all, establishments of state government. I mean, and the thing is that could probably be simply done. It wouldn't necessarily take a lot to do that. And what I'm getting at is creating a tool, a tool that we would all use that would say, okay, did we look at this way? Instead of having to get all the way through the process and then go back and go, oh, wow, we forgot this, we forgot that. So if we can create a framework, a new framework, it wouldn't be too difficult. I think it would just take resolve on behalf of the legislative entities involved to create that. But I think the intentionality around doing that would be a monumental step in mitigating systemic racism. So I just wanted to throw that out there to all of us collectively. But thank you all.
So we have only another 25 minutes or so together as House and Senate members. And so we do want to switch gears to look at a draft of an amendment to 119. And so Barbara, if your question is quick, let's go to that now. And if it's not, let's see if we can hold on to it and perhaps there'll be time at the end.
Either way, whatever is best. I don't want to stop the flow.
Okay, well, let's jump to 119. I think it's valuable since the bill resides in our committee right now. It's valuable for all of us to look at this together because this is a Senate bill that we are hoping to bring across the line before final adjournment in September. And so let's look at the draft of an amendment to this bill, and then we can have a few minutes of Q&A, and we'll come to you, Barbara, after that if we don't run out of time with the senators. So Bryn, thank you for being with us this morning. And if you would please tell folks where they can find a copy of this bill.
Sure. So good morning, everybody. For the record, Bryn Hare from Legislative Council. So on each individual committee webpage, there should be both a draft of the House Judiciary Amendment to S119 and also a side-by-side comparison of S119 that details on the left-hand column what the bill as it came out of the Senate looked like, and in the right-hand column what the amendment looks like. So I think that it may, since we've got the senators and the House members here together, I think it might make sense to do the walkthrough of the side-by-side, because then I can point out specifically where the differences are between the Senate version and the House amendment as it currently stands.
Thank you.
If everybody could pull up their side-by-side, I'll start the walkthrough there. So just to start off, I just want to make something clear, which is that the draft amendment has been edited and the side-by-side has not been edited. So there may be minor technical differences between the two documents, but that will be fixed shortly. But since the editors didn't get a chance to look at it until this morning, they have not had time to look at the side-by-side. So as I mentioned, the side-by-side has the Senate version on the left and the House amendment on the right. I'll just start out by pointing out that the House version changes the title of the bill to an act relating to a statewide standard for law enforcement use of force. So rather than referring to this as a use of force policy, it rather sets out the standards for law enforcement use of force. And it also doesn't specifically set those standards for the use of deadly force, but rather for just more generally the use of force by law enforcement. So section 1, you'll see that I've highlighted areas where the versions are different. And I'll draw your attention to those as we go through the sections of the bill. So since you don't have a whole lot of time, I'm just going to say that the subsection A is the definitions section, and the first 4 definitions, deadly force, imminent threat of death or serious bodily injury, law enforcement officer, and prohibited restraint are the same in the Senate version and in the House amendment. And also these definitions are largely the same as the version of H808 that House Government Operations looked at earlier in the session. So I'm not necessarily going to go through those carefully unless there's a specific question. Instead, I'm going to turn the page to page 2 and look at the 5th definition, which is totality of the circumstances, because this definition does have some significant differences in the House amendment. So the Senate version set out the totality of the circumstances as a pretty short definition, all facts known to the law enforcement officer at the time, including the conduct of the officer and the words and conduct of the subject leading up to the use of deadly force. A little bit different here in the House version, that it includes the words and conduct of the subject and the conduct and decisions of the law enforcement officer leading up to the use of deadly force. And then if you continue on to page 3, it sets out some specific considerations of what the totality of the circumstances is to include. So you see all this language on page 3, and going on to page 4, which is in yellow, is new language. So this, some of this language comes from the Seattle law enforcement policy for use of force. There's also some additional language regarding whether or not the subject is under the influence of a substance and factors that may indicate the presence of a mental illness. So I'm going to go through these one by one. So A is the seriousness of the crime or the suspected offense. B is the conduct of the subject being confronted as reasonably perceived by the officer at the time. And that includes 2 subsections here. The first is any signs of intoxication, impairment, or disordered thought that's related to the use or consumption of alcohol or controlled substances. Or subdivision 2, signs that the subject is suffering the effects of a mental disease or defect, or has a physical disability that impairs the subject's ability to understand or comply with law enforcement commands. Subdivision C, I'm at the bottom of page 3 now. The time available to the officer to make a decision. Moving to page 4. D, the availability of other resources, including non-lethal means to gain the compliance of a subject. E, include factors regarding like the physical characteristics of the officer and the person that the officer is dealing with. Factors such as age, size, relative strength of the officer and the subject, the skill level and training of the officer, and whether the officer or the subject are injured or exhausted. And then lastly, subdivision F is environmental factors and any exigent circumstances. So all of those particular factors fall under totality of the circumstances. So any consideration of what the totality of circumstances includes is going to include this whole list of other factors. Is that clear? That's pretty important since the policy really hinges on totality of the circumstances, including like you'll see objective reasonableness or the reasonable belief of the officer is throughout these standards. And all of those determinations are going to hinge on what the totality of the circumstances are. Is that clear enough for me to keep going? Okay.
Jim Harrison has his hand up.
Yeah, just a quick question, Bryn. Does adding all of these details make it more complicated in the sense that you've got to go through all these steps to see which ones you satisfy? I mean, I would think in the original language, it's sort of like a gut check by the officer quickly in his head or her head that of what they got to do. I'm just, I don't know. It seems like a lot of detail, and I'm just wondering if it muddies the waters a little bit. But maybe that's just me.
Well, I would note that these factors are going to be considered by the finder of fact in any case that's before a court, for example. So I look at these more of as something that as what a court will look at in determining whether or not the use of force was reasonable in a particular set of circumstances, rather than something that the law enforcement officer has to consider before using force. Does that make sense?
Thank you.
Representative Gannon, and then Senator Benning has his actual hand up.
Thank you. Most of these, are fairly clear, but going down to the final one, environmental factors and any exigent circumstances, can you explain that a little more, what that means?
So again, this is from the Seattle Law Enforcement Use of Force Policy. And because it comes last, I think that it's designed to sort of be a catch-all. What else is going on at the time? I read exigent circumstances to mean any other sort of pressing environmental factors that are going on around the situation. I do think, I agree that it's sort of a broader factor to consider, and I do think it's intended to be a catch-all.
Yeah, it's huge. I mean, could throw anything in there. I mean, are these known to the officer or just in general?
So to me, that reads as generally what is going on at the time, because exigent circumstances really means any pressing circumstances at the time. I think that you could extrapolate that they were known to the officer, but it doesn't specify that.
Okay, thank you.
Senator Benning.
Thank you, Madam Chair. Bryn, I'm assuming that these factors have been incorporated into the training of law enforcement officers in Seattle. Do you have any information that they have not been?
No, they are required to receive training on this policy. I don't know for sure what the amount of training is.
Okay, and just to follow up, are you aware of any court cases where this has been used to defend an officer who's been accused of violating the policy?
There are court cases. I'm not able to summarize those at this time, but I can certainly send you some if you'd like.
If you have links, I'd love to read them.
Sure.
Thank you.
And Representative Gannon, if I might just follow up on your question, I would just correct myself that the definition of totality of the circumstances is all facts known to the law enforcement officer at the time. And those are to include that long list of specific factors. So any environmental factors and exigent circumstances would need to be known by the law enforcement officer at the time.
Thank you.
Sure.
Representative Hooper, and then Senator Sears.
Sorry, Madam Chair, I was just rolling my finger over that, but since it did catch, this is, Bryn, intended for criminal type evaluation of an officer's behavior. Does delineating all this stuff have a civil impact also?
Yeah, so as we get a little bit further into these standards, we can talk about how these standards are likely to be evaluated. I don't think necessarily this would be have a criminal impact because you do set forth an affirmative right in this amendment or in the bill. I do think that it creates a civil cause of action, but I think that it's an open question whether or not it would have any impact on a criminal proceeding against a law enforcement officer.
Senator Sears.
Yeah, I just wanted to suggest, given that this is still in House committees, that we review this and hopefully finish it by noontime when many of us have to leave, with the understanding that at some point the House and Senate are going to have to reconcile any differences that are still there. And hopefully we'll be able to use a process that perhaps avoids a conference committee, but if necessary, that's what would take. So I just kind of urge us to look at this as the House proposal of amendment and see where you end up before we start to pick it apart.
Yes, and let's see if we can jog through this in the next 10 minutes, since I know the senators do need to leave.
Thank you.
Thank you.
Okay, so I'm going to pick it up again then. So I'm on page 4, about halfway down the page, subsection B, use of force. So just generally, I would describe the changes in this section are to set forth standards that apply to the use of force by law enforcement generally, as opposed to the use of deadly force. And we'll get into the standards for the use of deadly force in the next subsection C. So you'll see B1 is the same. B2 sets out the standard for law enforcement use of force generally. So it provides that law enforcement shall only use the force that's objectively reasonable, necessary, and proportional to effect an arrest, to prevent escape, or to overcome resistance of a person the officer has reasonable cause to believe has committed a crime, while protecting the life and safety of all persons. So again, that general use of force standard provides that use of force has to be necessary, has to be reasonable, and has to be proportional. And the standards here are going to get into what those words mean: necessary, reasonable, and proportional in terms of this subdivision, a little lower down. And I'll point those out as we go. And I just also want to point out, you see that subdivision 2 in the Senate version, that language doesn't appear here in the House version, except for a similar language is set forth in C2 of the House Judiciary Amendment, which is in the use of deadly force section of the standards. So you do see something similar there. That language doesn't go away completely. So I'm going to move on to page 6 now, subdivision 4. This language has been reworded slightly to turn the evaluation on whether it was objectively reasonable, whether the decision by law enforcement to use force was objectively reasonable, is evaluated from the perspective of a reasonable officer in the same situation based on the totality of the circumstances, which we described earlier on in the definition section. I highlighted the language in subdivision 5 in the Senate version there. You see it doesn't appear here in the House version, but you can find that language or a modified version of that language in subdivision 2 of subsection B. So that language also from the Senate version doesn't disappear completely. Now that's a little confusing. Let me know if you need clarification there. Otherwise, I'm going to move on to subdivision 5. So this is language that also comes from the Seattle policy, and this describes what the word necessary means in the use of force standard that we went through in subdivision 2. So it provides that the use force is necessary if no reasonably effective alternative to the use of force appears to exist, and the amount of force used is reasonable to effect the lawful purpose intended. And whether using force is necessary, again, is based on the totality of the circumstances at the time that the force was used. So that sets out what that word necessary means and when it's appropriate to use force. Subdivision 6, I'm on the following page, page 7 now. This talks about what the word proportional means with respect to that use of force standard. So force is proportional if the level of force applied reflects the totality of the circumstances, including the nature and immediacy of any threats posed to the law enforcement officer or to others. Proportional force doesn't require officers to use the same type or amount of force as is used by the subject. And then you'll see this is sort of a broader statement. The next statement is a broader statement that the more immediate the threat and the more likely that the threat will result in death or serious bodily injury. So essentially the more serious the threat and the more immediate it is, the greater level of force that may be proportional, objectively reasonable, and necessary to counter it. Again, that's all language that appears in the Seattle use of force policy. I'm on subdivision 7 now. I know I'm rolling through this. I will listen for the chair if you interrupt me for questions. Bottom of page 7, subdivision 7 is a new section. And this language really describes proactive steps that law enforcement should take if feasible prior to using force. This language is essentially describing de-escalation tactics and techniques. And it comes from the Justice and Policing Act from the Congressional House of Representatives. So prior to using force, law enforcement, if feasible, shall take proactive actions to stabilize the situation so that more time, options, and resources are available to gain a person's voluntary compliance or reduce or eliminate the need to use force at all. And those would include verbal persuasion, warnings, tactical techniques, slowing down the pace of an incident, waiting out a subject, creating distance between the officer and the threat, and requesting additional resources to resolve the incident. I'm going to move on to the next subdivision now, Subdivision C. So this sets out the standard for law enforcement use of deadly force. Subdivision 1, language is largely the same. Law enforcement is justified in using deadly force upon another person only when, based on a totality of the circumstances, such force is objectively reasonable and necessary to do one of the following. And this language you see is the same. A is defend against an imminent threat of death or serious bodily injury. Imminent threat of death or serious bodily injury is defined. Or apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury if the officer reasonably believes that the person will cause death or serious bodily injury to another unless that person is immediately apprehended. That language, same as the Senate version. Subdivision 2, this language is new. This is a description of what the word necessary means in context for the standard for use of deadly force by law enforcement. So the use of deadly force is necessary when, given the totality of the circumstances, an objectively reasonable law enforcement officer in the same situation would conclude that there was no reasonable alternative to the use of deadly force that would prevent serious bodily injury or death to the law enforcement officer or to another person. And when feasible, law enforcement officers shall employ all other reasonable means before resorting to the use of deadly force. And that sort of reiterates that language that you saw in subdivision B7 about de-escalation tactics being required. Next, I'm going to move on to subdivision 3. I'm on the top of page 10 now. This is also new language. Law enforcement officers shall cease the use of deadly force as soon as the subject surrenders or no longer poses an imminent danger of death or serious bodily injury to the officer or to another person. That language also comes from the Seattle policy. The remaining language on pages 10 and 11 that details the policy for the use of deadly force by law enforcement is the same. There's no difference there until you turn to page 12 and we get to subdivision 7. And this is the language that relates to prohibited restraints. So you can see, if everyone's with me on page 12, the Senate version prohibited law enforcement from using a prohibited restraint as it's defined in the bill for any reason. And the House version here provides that law enforcement officers may use prohibited restraints, but only in a situation where the use of deadly force is justified and no other intervention is available to law enforcement to defend against an imminent threat of death or serious bodily injury. Again, that's a defined term, to the officer or to another person. some additional language there that provides law enforcement is not justified in continuing to use a prohibited restraint when there's no longer an objectively reasonable belief that the suspect continues to pose an immediate threat of either death or serious bodily injury to the officer or to another person. And lastly, that subdivision 8 is the same language that appears in the Senate, requiring officers to intervene if they observe another officer using a prohibited restraint on a person. So that.
So Representative Lalonde, briefly before our Senate colleagues need to go to their next meeting, wondered if you would frame up a little bit about where this came from.
Yeah, no, I'd be happy to. So this came from really looking at a lot of different sources, looking at various policies. Seattle policy has been mentioned. I was kind of pointed to that after a discussion with Julio and David Scher at Attorney General's office about where to go with this bill. And Julio had mentioned that Seattle has one of the best policies in the country. He mentioned a few others, but I knew this one would be close to Representative Burditt's heart. So I looked at that one particularly. But there are policies in Vermont, including in South Burlington, which is very similar to the policy that's in Seattle. So it wasn't just looking at Seattle. I looked at several around the state of Vermont. Also spoke with some state's attorneys who gave some input on this. Spoke with a professor who has written about this. And looked at a number of law reviews and cases, et cetera, to come up with some proposed language, which I'm sure will go through the ringer with testimony over the next week and a half. But just wanted to let you know where these ideas came from. And I'm happy to expand on that if anybody wants to know a little bit more.
So thank you to Senate Judiciary for joining us in this joint hearing this morning. I know that it's a short amount of time, but we do appreciate the opportunity to look at these proposed changes together and trust that we can work together over the coming weeks to iron out a final bill.
I hope so. If you could get us a timeline, that would also be helpful. Since two committees are working on it, sometimes it takes longer in the House. And so we need to know a timeline. My understanding is we're adjourning about the 25th of September. So,
yes.
It won't give the Senate much time to react if we're not working together on this.
Exactly. So chair to chair, we'll have some conversations in short order.
Thank you.
Thank you. So I wanted to go back to Barbara's question.
Okay, so is our witness still here actually?
He was a moment. Yes, he is.
Okay, so in trying to take in everything in the report, and please tell me if this doesn't feel like a fair question, but I'm wondering what would success look like for you in what we end up doing for the rest of this session? I mean, I feel like you have a really great handle on some of the parameters, but it would be sort of good to hear your vision of what would be really important to accomplish.
I have kind of an odd idea. Julio Thompson, I am honored to call a friend.
Me too.
And one of the things that I enjoy about Julio is his just sort of boundless and protean intelligence. One day we were talking about consent decrees because he's been involved in many of them, really. And while we were talking, I had one of my moments and I said, why can't the legislature create a consent decree for itself? And Julio kind of paused and he kind of went, and I went, I know you're going to do precedent at me. And I'm going to say I'm not a lawyer and that I don't care. Because I like the idea the body setting for itself a timeline of saying, here is the big picture, or shall we say, here is one big picture. And we're committing that at this point, we're going to be able to do this. And at this point, we're going to do this, and so on, as police departments who are under DOJ jurisdiction during the consent decree do. And what I like about that is it gets us past a problem that really arose certainly after the murder of George Floyd. And I will admit to an extraordinary amount of personal frustration with, we need to do it now. And reactivity, I'm the son of a social worker, of a psychiatric social worker who is extraordinarily wise and brilliant. And she has, she's given me everything I have, I think, to this day. And one of the things that I have learned from my dear mother is that reactivity is a terrible space from which to act. And it felt like we were all reacting after May 25th. And I feel like there's a lot of legislation that was rough around the edges. I certainly know things I brought back to various panels and committees that I'm on. People were angry. And I feel like a consent decree would make it clear, first of all, because it's not done. It would be so clear to the world that Vermont is doing something really different and serious about this. That we're going to put something, you know, it's not unprecedented in law. It's certainly not. It is a legal idea. But that we're going to put something together here and we're going to use it very unconventionally. We're going to put ourselves, speaking as a legislator that I'm not, we're going to put ourselves on a consent decree. We've taken testimony from community members about this. Here are some deadlines and here are some things that need to happen. And we're not going to rush it because we know that after 4 centuries, rushing it is nothing more than lip service. That's my fantasy.
So one, I'm glad you listened to your mother. Yay. I'm a social worker, so double yay. I agree about the reactivity, and I just want to say 2 things. One is when Representative Morris and I were both serving together, we started the idea of doing a racial impact statement requirement on legislation, and I've committed to trying to see that out. So I have H362, which didn't get any action this year, but I think that would help us with reactivity if we're
Absolutely.
And the only other thing I'd say is, while I appreciate reactivity, if silence feels like it would be being complicit. And so I see your point about a consent decree, and I'd be curious to hear from my colleagues if that's binding future legislatures.
You know, I don't know.
Yeah, thank you very much.
You're welcome.
So Mike Merwicki has his hand up.
Thank you, Madam Chair. Thank you, Eitan. And
Absolutely,
greetings from the other side of Putney. I appreciate the idea of a consent decree, and it makes me think we're getting ready to pass a Global Warming Solutions Act, which I think does something very similar, which holds the state to some standards.
Exactly.
And allows us to I forget the term now, but we can take action. So I'd like to follow through on this and see what we can do with it. Thank you.
Great.
Thank you so much. And committee, any other questions for Dr. Nasreddin-Longo before we switch gears? All right, so I appreciate you, you know, framing up this urgency that we all feel. and also, you know, suggesting some restraint in terms of how we act on that sense of urgency. Maxine?
Yes, thank you. Thank you as well. I want to echo those thoughts as well and look forward to working with you more. Thank you.
Yes, thank you, ma'am.
So at this point, House Judiciary will meet separately and move on. But I want to thank you, Sarah, and your committee and everybody for this. This was helpful. House Judiciary, know that tomorrow morning we will be doing another walkthrough of the amendment. So I know Bryn went quickly, but it was important having House Government Ops and Senate Judiciary here to get through that. But we'll do that again tomorrow in our committee. So okay, thank you. So we leave and I guess you stay, right?
Yep, I think we can go off live and then we will resume this on the GovOps live stream. So thank you all for joining us this morning and see you soon. GovOps, you guys can stick around. We'll switch gears here when we have our committee room back together. Or maybe we'll stay on live.
Madam Chair, we are on live on the House Government Ops YouTube page.
All right, we will stay here and House Judiciary will rejoin their meeting in their committee room. I don't know about you, but when I see just our committee on my Zoom screen, it looks so much more manageable than the 30 or so people we had in the last meeting. All right. Looks like we are here together, just as the House Government Operations Committee. The second part of our agenda for today was to continue committee discussions on the budget recommendations that came to us last week. And John had led us through a few of them. We had some more discussion to be had with other parts of the recommendations. And so, John, if you want to just orient us to what we've checked off and what we still need to come back to, that would be very helpful. Except that we can't hear you.
My apologies. Let's start with body cameras first. So that impacts both the Department of Public Safety's budget as well as the Sergeant of Arms budget. With respect to that, I reached out to Diane to see if we could get costs for equipment and storage, or no, storage and training. I have not heard back from her yet with respect to that. And I did email her on Friday, but she did get back and say she would look into it. So I don't have an answer for that. I also, with respect to body cameras with the Vermont State Police, I did trade emails with Commissioner Sherling over the weekend and yesterday with respect to language that they would like. That's a slight tweak to the language we had in S219 with respect to who was required to have a body camera in the Vermont State Police. And the language they came up with, hold on, where is it? Here it is that the department shall ensure that all members assigned to the Vermont State Police Field Force Division who routinely engage with members of the public related to the enforcement of the laws are equipped with a body camera or other video recording device of his or her person. So this is similar to language that MEDA came up with respect to it be people in the field. So this would not include the colonel or the majors or special investigation units. But just to remind people, Commissioner Sherling did indicate that if we were to include all those different types of people, it would double the cost of the body camera program. So this would limit it to people who are in the field. I did go back and forth with him with respect to our concern that in emergency situations, anybody who's in a uniform can be in the field, but his comment back to me was it's unusual, and the cost is significant. I also, just so you know, I reviewed the governor's letter when he signed S219 about the other video recording device language. He thought that the governor thought that was confusing. Commissioner Sherling is now fine with that language and does not have a concern about that, because there may be newer technology that comes out that may be used rather than body cameras. So that is no longer an issue for the administration. So that basically, I think, summarizes that issue. So I think that the things that we need to decide is if we're comfortable with this language, and if we support the Department of Public Safety's current plan for use of body cameras.
Committee discussion. Jim Harrison.
I don't know what the right language is, and I guess I would defer to you, John, if we knew from the budget overview presentation that either we got to increase their budget or we have to make a change, because the wording we put in 219 may not have been as clear as we had hoped. You're the lawyer. I would guess defer to your judgment as to whether or not this does it. And I guess what the commissioner was saying to you, don't let perfect be the enemy of the good, in terms of that, once the rare circumstances where everybody is involved in an emergency.
Yeah, I mean, he presented a convincing argument for, everyone in uniform can at some point be in the field. And the other thing he argued is typically if somebody like the colonel or the majors are in the field, there's going to be other officers in the field that will have body cameras, and that things will be captured on video by one of those cameras.
I would like to see the video footage, though, of that traffic stop and that one of our members was involved with a few years ago.
Other committee discussion? Rob?
Thank you, Madam Chair. So, John, based on your conversation, it looks like that the majority of that language came from public safety.
All of it came from public safety.
All of it came. And so they're comfortable that, one, they can operate within that language, and two, that it addresses the majority of the concerns that others may have.
That's correct.
Okay, very good. Thank you. Well, that said, I can't think of a reason why I wouldn't support that.
Okay.
And I should say there's one other tweak that they made, which dealt with adding unallocated costs to 2021 budget. They could be removed because the project's already funded. So that's more of an appropriations thing, but that's also language they gave to me.
Right. It sounds like we have some consensus around the VSP body cam issue. Marcia?
Just a thought on this, but usually when you buy equipment, you have a few extra pieces of equipment in case one fails. So it could be that if a situation arises where people who don't normally go out into the field have to take a vehicle to an emergency situation, that they could possibly have some extra equipment with them that they could use at that time. Just a thought, but it would make sense that there would be a few extra body cams around.
No doubt. Oh. All right, so we are still waiting for some more information from Representative Landfer on cost of storage and training. So that is a lingering question. Was that all of the budget questions that we had left to decide on?
I think we were taking the mental health issue off our plate of mental social workers, those 7 positions that are in the Department of Public Safety's budget off our plate.
Yes. Yeah, that's really an issue that the House Healthcare Committee has been dealing with for a number of years. And so the wisdom of that policy really needs to be evaluated by the Healthcare Committee. And just because it's in the DPS budget, it popped up on our to-do list. Jim?
Yeah, do we need to talk about the body cams for the sergeant of the Capitol Police, I should say?
We are waiting for some more information, but we can certainly have a committee discussion about that right now. Did you want to share your thoughts?
No, I mean, we talked a little bit about it.
Wow, that's unusual.
Yeah. Madam Chair, would you please ensure that other members don't interrupt? That would be helpful. I'm still.
I do have the all-powerful mute button, but I try not to use it. You're all duly elected.
Yeah. Well, I have to go up to the mailbox because I'm expecting something in the mail shortly. I'm sorry. You know, we had a brief conversation. You know, my own feeling is if it's not too big an ask, that we should, and with the current events being what they are, with all kinds of interactions, I guess I would encourage us to be consistent with what we're requiring the state police to do with body cams, if at all possible. But next year is going to be probably a year like this year, which will be totally different again. So, whether we did it for this fiscal year or we postponed it, either way, I do think we should go in that direction.
Yes, and I have reached out to a few other members of House leadership because I recall having had conversations about cameras in the State House a number of times. I have not gotten a clear answer yet, but I do have another meeting tomorrow afternoon that I can where I can get some feedback. I personally am uncomfortable with it at this moment, but I'm willing to be open-minded and continue this discussion. JP?
Yes, Madam Chair. I just wonder if we might be able to hear from the chief of Capitol Police at some point real quickly. It shouldn't take him too long, I wouldn't think, but on this matter in particular.
I would imagine that we can, because I think he's fairly available. Do you know, John or Jim, if the chief was in House Appropriations for any of the conversation there?
We were only part of the conversation with respect to the Department of Public Safety. We were not in the room when the Sergeant of Arms discussed their budget.
Okay. Well, then it's a fair question. Bob Hooper.
Forgive me if I've forgotten what you said earlier, but is the hesitancy that was in the past about cameras and audio freedom of information stuff, or what was it based on? And then don't we have the ability to exempt that if it is?
Yes, and yes. There's a number of different levels of concern that I've heard people express in the past about recording what could be casual hallway conversations at the State House. And whether, you may think that you're having a private conversation in the card room that is only being viewed by the 3 or 4 other legislators in the room. But if the camera is rolling across the room, then that is potentially discoverable from by anybody in the world who wants to submit to request that footage. And I just think we ought to understand what that means in terms of how far and wide that information goes out in the world. And I think, to be fair to our colleagues, we ought to have an open conversation with them about it and not sneak something in, quietly in a budget during a pandemic that nobody else is going to look at or even really recognize. This has been well trodden in years past, and I just don't feel comfortable moving this through without letting people kick the tires a bit. John?
Thank you. So there's a confluence of 2 policies here. One is public records law, but there's also going to be the model body camera policy that the Department of Public Safety is going to come up, which the Capitol Police are going to comply with. I mean, I really think if we want to make sure we make the right decision, not only do we need, input from, other members about how this is going to work, but to make sure that the body camera policy and public records are both, going to protect members the way we want them to, and we're sure that the Capitol Police are using, that the policy is appropriate for the Capitol Police. I think it would be wiser to postpone this decision until January, where we might have some more time to deal with it, rather than during this crisis situation, because I don't think we'll be meeting in person between now and then, and maybe only briefly in January at the start of the session. So I think rather than rush this one, it might be worth doing more homework.
Marcia?
I agree with John. I hate to kick the can down the road, but given COVID, I'm wondering if this appropriation even needs to be in this budget, or if it could wait until the next budget cycle, because we just don't know what's going to happen in the State House and who it's going to be open to. Thank you.
Rob?
Thank you, Madam Chair. I guess I'm going to have to agree and disagree with a couple of my fellow committee members here. One, I do feel it's critical that we do hear from the chief and understand their request, and two, what they would interpret how it would be used. I'm very uncomfortable in we're proposing things for other people, but yet not willing to have them apply to us. And I don't feel that that is appropriate. I do feel that it is appropriate to have this conversation now. This is not a new conversation. This is not a new request from law enforcement. And because we're going into somewhat uncharted territories again in a new session, there's going to be all sorts of different demands and expectations of our Capitol Police. And it's highly likely that we're going to be in very different physical locations. And our Capitol Police, I think, have a unique responsibility in that when we are in session, if we ever are back there physically, the expectations are quite different there with people, whether it be protesters, interaction with, fellow lawmakers. So I do feel that the time is right, and I don't know why we would hold our Capitol Police to a different standard than what we would hold Vermont State Police or any municipal law enforcement. I think we need to give them the tools that they need to be successful in what we ask them to do.
Well, to be clear, we don't require every law enforcement agency in the state to equip their officers with body cameras, but
There's
we
language
can
out there
take some
proposing
time.
that.
We can take some time to have this conversation with the Capitol Police, and we'll make sure that we add that to the schedule. Any other committee discussion on this? JP?
I think, Madam Chair, we also might consider inviting the Sergeant of Arms as well, to give her input onto this to the committee, as well as the chief.
I appreciate that. Okay, so we are done with each of the budget items that we have the ability to act on right now. The only other thing that I wanted to have as committee discussion was really a conversation about spreading the workload a bit with respect to the police reform bills. I am struck by the fact that many of the components in S119, while they may technically fall under our jurisdiction, could equally be considered by the Judiciary Committee. I would like to give the Judiciary Committee green light to work on revisions, because I know that they've been doing a lot of work in this off session to look at model policies from other jurisdictions, as you saw in the draft that Bryn just went through with us. And I would be happy to make sure that our committee still has the opportunity to weigh in and make a recommendation on the bill. But I think it makes sense for our committee to send the bill officially downstairs virtually to the House Judiciary Committee for their work on it. They only have one other bill to do during this September session. And as you know, we have one that we've already completed and two more that we need to complete during this session. So I think that evens the workload a bit, and would welcome any committee discussion on your thoughts on sharing some of the work with our friends from downstairs. Jim?
Thank you, Madam Chair. Would we get the bill back under that scenario? So we could then accept their recommendation of amendment or tweak it? Or are you suggesting we just give the bill to them?
I would think that the cleanest way to do it would be to refer the bill to their committee, and then for us to send a memo to them responding to the changes that they make before they vote it out of committee.
That's an option, I guess. And this is no slam on House Judiciary, but I trust House GovOps because it is so talented and hardworking more. So my biases are coming through. Sorry.
Yeah. Any other thoughts, questions, comments, suggestions? Don't all jump at once. All right. Well, I will, I'll arm wrestle for it with Maxine. How's that sound?
My money's on you. Don't disappoint us.
Yeah, you'll win, Madam Chair. No worries.
Body cam.
So yeah, in all seriousness, we do have plenty to keep us busy for the next several weeks, and I will talk with the speaker and with Representative Grad about the most collaborative and most efficient use of resources here in considering these bills. So anybody have anything else they would like to discuss here while we're in committee discussion? Excellent. Nobody's diving for their little blue hand. We will be back to S220 tomorrow with a few folks who will join us in order to answer some of the questions on S220. And then on Thursday and Friday, we are blocking off both of those committee days to hear from folks who would like to share their thoughts on S124, which is the Municipal Law Enforcement Amendments Bill. Rob, your hand is up. Do you have a question?
Sorry, Madam Chair, no.
Okay. All right. So looks like we get to adjournment a little sooner than we thought today. So you gained a half an hour on your day. Bob Hooper, do you have your hand up?
Yeah, Senator Sears made a passing comment about when he thought we were going to adjourn. Did that have any credibility, and what was that date?
He said the 25th, and I believe that is a credible target date for adjournment, because if you look at the calendar for September, you'll see that the 25th is a Friday. The theoretical drop dead date is September 30th, which is the following Wednesday. So I think the idea is to try to finish up on a Friday and not spill over into the following week. The first quarter budget that we passed back in June will be done on September 30th. So we definitely need to have our work completed on the budget by then.
Thank you.
All right. Well, it was good to see you all this morning. Thank you for your great work. Jim, good job on the floor. Yours went smoother than the other bill that we had on the floor this morning.
God, he's surrounded by a talented and hardworking committee.
That's right.
Can we assume the other bill passed easily, or?
There were 14 no votes. And so
Okay.
for minutes of debate versus relative to no votes.
Right.
Yeah.
We had 0 no votes, 0.
And only a few requests for more information because your initial report was so complete.
Well, we are talented.
You don't know how hard this committee, well, you don't know how hard this committee had to work behind the scenes to answer questions that you were going to be asked.
Too much fun.
And here you thought Rob was planting questions out there.
Just trying
He
to help,
was.
Madam Chair.
He was,
Trying
but
to
they were
help.
all
They did-
answered in the presentation.
Yeah, just because they didn't get asked doesn't mean they weren't planted.
All right. Well, you folks have a fine day today. It looks like a lovely day to get out and get some exercise. So do stretch your legs a bit, and we'll see you all here tomorrow at 8:30 early in the morning.